It's, mic's on. 6:01, thereabouts, so we'll call the meeting to order. First order of business is the minutes from July 9th. Just got. We just got them. Actually, I don't have a copy of it. Hang on. All right. So we just got them, so I'll make one to make the next meeting, but we have time to review them. I'll make that motion. I'll second. All in favor? Aye. Opposed? So we'll review those next meeting. Under business mural, Jason's here to the attorney Jason's here to discuss the recent court decision about murals and to talk to us about murals in the town of Lincoln. Jason, welcome.
Thank you very much. Good evening, everyone.
Good evening.
So, Carol had presented some questions to me as a basis for the conversation. I can kind of go through and answer the ones that I have, or if anybody there just wants to ask questions and do it organically that way, then I can hear those questions and respond to them. So it's up to the board how you want to kind of go through the conversation.
I think I'd like to start off by addressing the questions. There was three that were submitted, or from three people on board. OJ submitted a couple, Sue submitted one, and I submitted 3 or 4, or 5. So
yeah, so Paul, I have them. What I will do for the sort of sake of the, I guess, the record, but also to make sure it's clear for everybody what I'm answering, is I will state the question that was provided and give you the answer that I have for it. And so in no particular order, I think maybe the order I got them. Paul, you had 5 questions. The first one being, would you consider the town of Lincoln sign ordinance content neutral? That is a loaded question in the sense in that the ordinance has a lot of sections. So the best way that I can answer that, and I can dig into details, is yes, mostly. There are some sections that, depending on how it was applied, which is what the Conway case was, by the way. It was an as-applied challenge, meaning how the ordinance was applied to that sign, not a facial challenge, meaning not a challenge to the entire thing essentially being unconstitutional. That sort of procedurally matters in these cases. It dictates a little bit of how they go. But so, for the most part, I went back through it again, the whole thing, and made a number of notes, which I could provide in a subsequent memo, perhaps, just to highlight what those are. But I think overall, it is a quote-unquote constitutional ordinance. There are some provisions that could be challenged depending on how they are applied. One of the newer things sort of coming out of legal decisions is the whole temporary sign thing, for example, right? And so what I mean by that is if you allow temporary political signs as being exempt from the sign ordinance, but don't allow a temporary sign that says save the earth or you know, any other type of a political type message, that is arguably not content neutral, because you are allowing some content preference that you are another. So that depends on how that comes out in practice. But that could be one of the sections, for example, in the current ordinance that could be deemed not content neutral. So I'll stop with the answer to that one unless anybody has any follow-ups. And I don't know, it might make sense if there are follow-up questions to do it with each question, although that could, I guess, in theory, make it a long conversation. So Paul, I'll let you as the chair tell me if you want me to just go through the other answers and then everybody ask their questions at the end, or if you want to do it as follow-ups to the bigger original questions.
I think as we ask, as you answer the questions, if we have any follow-up, I think it'd be good to go by the each. I have a question on this. You said that you reviewed it, you reviewed the ordinance for it, to see if it was content neutral, and you had some suggestions. Are you gonna be able to pass those off to the town of Carroll so we can take a look at that and see? So we
Yeah,
can
I'm
see-
more than happy to do that. The way I would do that, at least in the first instance, as it would be as an attorney sort of client privileged memo to the town. Obviously, that doesn't mean it's forever and always privileged in attorney-client privilege and not confidential and not subject to 91A. But at least in the first instance, I would present it in that way so that the town officials could look at it and determine what they want to do with it. Of course, if there's ever going to be a proposed change to the ordinance in response to a suggestion that I provide, then it's certainly public anyway. But as the town's attorney, in discussing those things, there's at least some piece of that. For example, if I said a memo and I said, here are the 10 things that are okay, and here are the 3 things that are potentially a challenge, that's entitled to some protection, unless and until it's not. So that's the way, Paul, I would envision myself doing it and I would probably provide it to Karina and to Carol as the town manager and the planner, who would be able to get that where it needs to be and evaluate it, including obviously getting it to the planning board, because that's where changes to the ordinance would ultimately, non-petition changes to the ordinance would originate. So if that's okay, that's what I would do. It would be a memo, and it would essentially go through the whole thing. It wouldn't be, as long as the ordinance, because I'm not going to talk about all sections, because if it's totally fine and there's no issues, then I would just not address it. But anything where there's a question or a concern, I could highlight that. And if I have a suggestion that would address the concern or make it less susceptible to a legal challenge, then I'm happy to do that as well, all in one document.
Thank you. I think that answers my question. You're getting, you sound like you're in the middle of a stadium or something. I don't know what it is.
Cal, you turn this TV off, I mean, volume up,
That was.
Yeah, it's-
Yeah, you wanted to reverb.
and that's like a half a second behind it. Just turn the volume down. 0. You should.
So, yeah, I don't think there was anything technologically on my end. I'm in my office. So I don't know that that's creating an issue, but hopefully whatever it is better now and it's easier to, can hear me better. The second question, Paul, that you had asked is, can Lincoln define murals different than signs? Yes, of course you can. However, the definition. Oh, sorry.
I'm sorry, no, it just made it sound a lot better now.
Got it. So I'll repeat what that question was, which was, can the town define murals different than signs? And my answer to that is absolutely yes, you can define murals as different than signs. However, having 2 separate definitions doesn't in and of itself avoid whatever the potential problems might be. For example, it's arguable that if you define murals separately, it just becomes depending on what the definition of sign is, a mural is simply a subset of a sign. So all murals are signs, not all signs are murals kind of thing. If you define it such that it is its own totally separate thing and that it is not a sign, then the sign ordinance would not apply at all, and therefore there would be no regulation over murals because they're not subject to the sign ordinance. They're not signs. So you can't regulate a mural if it's not a sign in a sign ordinance kind of thing. So that's one thing to keep in mind, is how you define them ultimately does not in and of itself save the day from a potential legal challenge. But it also, depending on how you define them, could limit your ability to create rules and regulations more than you would need to be limited to pass constitutional muster, so to speak. So again, the answer to that is yes, but it's unfortunately with First Amendment and constitutional stuff with signs, it is not as easy as just creating one new definition for mural and sign. And I can talk more about that if there's follow-up questions. So third question is, can murals have different standards than signs, size and location? The answer to that is probably not, because if you say, here's these murals over here on the one hand, and just do whatever you want, wherever you put them, whatever's on there, whatever size, but signs to like advertise a business, for example, have to be limited in number or size. If you do that, you are likely creating the ability for someone to challenge that on a content basis. For example, in the Conway case, Levitz, the bakery, said, you can't treat us differently than if the sign was across the street, not on our business. So we think it's art and we think it's a mural. So we get to keep it. The town of Conway said we're regulating based on size. And the town's argument that we're only regulating based on size did not ultimately prevail in the federal court. Now, part of the reason it didn't prevail is because the judge, Judge LaPlante, the federal judge in the case, made the factual determination that the town didn't really regulate anything other than commercial speech, which the judge determined you couldn't do under the constitutional, free speech jurisprudence. So if you set it up that one category of graphics, let's say, and I'll just, as a brief aside, that was a funky little piece of the case. We had to agree on what to call this through litigation. The bakery wanted to call it a mural. The town wanted to call it a sign. So we all agreed to call it either a graphic or ultimately a display is what was used most frequently, to be as neutral as possible. So if you treat different types of displays different based on anything that is content based, that would be potentially and perhaps beyond potentially likely problematic. And the reason it's only potentially problematic is because at the end of the day, there's only a problem if somebody doesn't like it and challenges it. I mean, that's the practical reality. 4,
Hey, Jason,
yeah,
so said that we could not, it's not advisable to have standards different from murals than a sign. If you did create those standards from murals differently than signs, does that make it problematic because it's then content? And how do you get content out of a mural? That would be my question. I mean, murals really don't have any content, right?
artistic expression. It doesn't have, it could be, so I will tell, this is the best way I can perhaps describe how difficult it is in deciding whether something has content. So obviously part of this depends on the definition of sign, but what Judge LaPlante asked, and he was dead serious about this, it wasn't jest, it wasn't him being sarcasm. He pointed to the back of the courtroom and he said, the back of the courtroom, that's just a white wall. That conveys information, doesn't it? And so there is content. If you do a mural that is just mountains versus mountains and donuts, and I'm obviously bringing the Levitt case to bear in this part of the discussion, those both have content. Where the town was deemed to have faulted is that they were defining sign as conveying business type information. Content is anything. It doesn't have to be advertising a single thing to be content. And I mean, you can just think of this sort of from a common sense perspective. If you think about it, art, for example, there are people that look at art and think it's the most wonderful thing in the world and pay thousands and thousands of dollars for it. And some people look at art and think it should go in the trash. One of the easiest examples that I can think of that is polarizing is Jackson Pollock. some people think he's just splashing dots on canvas and it's just paint splatter. And some people spend many, many, many thousands of dollars to get a Jackson Pollock. That is content. His paint splatter on a blank canvas is content. And if you said we can't have spray paint splatter, but we can have stripes, you've made a content decision. You don't get to decide as a governmental entity the artistic merit or quality or whether you like it or not. And that bleeds into some of the other questions too. So the bottom line is anything that is expressed as a graphic or depiction will be deemed to be content, whether it's selling something, advertising something, or not. Political, business, you spray paint a dog on a wall, that's content, whether it's a pet supply store or not. And that was a case as well, actually, where somebody had put a mural out, I think in Virginia, on a pet supply store. It was deemed, of course, to be a sign, and it could be regulated as commercial speech, but it could not be regulated based on sort of the artistic merit.
So Jason, content is a blank wall, the content is a graphic. And it kind of goes to my next question about, regulating what graphics. How do you regulate what you can and cannot allow if it's all content? I mean,
Gotcha. So that was your fourth question. So that's a good segue. So I have an answer that I prepared to give you that, but I will give it to you now directly in response to the follow-up as well, which is, in my opinion, there are few and far between things you can do with content. You can regulate and ban obscenity, for example. However, what is obscenity is not something that everybody agrees on. There's a famous line in a United States Supreme Court case where one of the justices says, "I can't define it, but I know it when I see it." Not too helpful. It has to basically be something that has no artistic merit and really only appeals to the prurient interest, which is sexual stuff, and have no other sort of redeeming qualities. And I can,
in this day and age of discrimination and the rest of the things that happen out there in the world today, it seems like you can't refuse anything or judge anything based on what it is.
that's not a totally inaccurate statement. For example, a swastika.
Yeah.
Different people have different opinions on what that is. I mean, ask some Buddhists and they have a different opinion. But be that as it may, it was co-opted by a group that at least draws strong opinions from many, many, many people in the world. Unless that swastika, where it's placed, is deemed to be fighting words or an actual incitement to violence, even that, arguably, hate speech in and of itself cannot be 100% banned unless it has one of these other types of pieces to it. And so if there's an actual threat in the speech, if it is fighting words, meaning in trying to incite violence, or if it is in fact essentially calling to people to create violence, towns and governmental entities can ban that type of stuff. For every, pride flag, for example, in theory, there could be a flag that is sort of anti those types of rights. And both of them equally allowed under free speech, regardless of what your personal opinions may be on those. Now, caveat to this is if it's governmental property, the First Amendment doesn't actually really apply to governmental speech because governments in and of themselves have philosophies and policies. So if on town land you don't want to allow things or town property, then you can do that with more freedom. That said, there was a recent case out of Boston, I think it was, and it was a public area. And sort of it came to be a place where different groups and organizations were allowed to occasionally put flags up, whether it was seasonal or just, one per month, this group, this organization. And then the town, and I can't remember what it was, whether it was a pride type flag or a religious type flag, but one of those sort of potentially politically polarizing things. And they didn't allow it. And what the court said in that case is because you had been allowing private entities to do this, you deprived this public place, this governmental land, from its protection. So if the policy had been no flags by anybody at all, then it would have been okay. But when they let a whole bunch of other private entities do it, they then opened it up that they would have had to have allowed religious flags, pride flags, whatever else. So it really depends on how it's used. But if it's strictly governmental property and you say, nobody is going to say what they want here, you do get the right to do that. That actually reminds me of one of the other things that I want to say with regard to the content neutrality. If you allow governmental flags, to your point, Paul, of everybody, you can't, then you have to allow other flags too. Like you can't say if it's a governmental flag, it's exempt, but no other flags. That will probably get you into, and it has gotten some municipalities already, not any in the state of New Hampshire that's gone through the court process, but in other states, whether it be federal cases or state cases, generally it's going to be federal because we're talking about the United States Constitution, and not zoning stuff. But that can get you into trouble. And I think there's an aspect of that in the Lincoln sign ordinance. So just as a practical pointer, that could, somebody could challenge that and say, well, if you allow my neighbor to have 27 American flags, you need to allow me to have 27 Star Wars flags. And I'm picking something that's not as politically polarizing as Star Wars, I hope, or I don't think it is. But that it kind of goes that far.
OJ has a question for you.
Yep.
So Jason, in our current sign ordinance, we have a list of signs that are allowed, but are exempt from a sign permit and sign fees. And
Right.
all of these, you need to look at the sign and look at the content to determine if it's exempt. For example,
Right.
Traffic, safety, parking spaces, loading spaces, stacking lanes, entry and exit drives, direction of traffic flow. All of those are exempt. Signs indicating open and closed sale of business hours that are limited to 2 square feet are exempt. Could we add into that section a thing that says that murals are exempt, and then go back, obviously have a definition of what a mural is that defines it differently from a sign? Obviously, it's content-based, just like these are, to determine whether it is a sign or exempt. But it wouldn't be, it would be content neutral, once you've made that determination.
Yeah, I think that is the best possible way to deal with murals if you don't sort of care where they are, how big they are, what they look like at all, in a way that would be content neutral. There was actually a case that came up and it dealt with the issue of signage. And the argument that was made was, well, if you have to look at it at all to determine whether it's a sign, then you're making a decision based on content. You can't do that, which in theory would mean you couldn't have a list of exemptions because you have to look at it and to see what the content is to make. But the court said more or less, all right, we got to use a little bit of friggin' common sense here. And, without getting into the aesthetics of it, if you're making a determination of whether it fits a definition, then you can do that. And so in one of the interesting pieces about the Levitz case is that it wasn't actually a mural because it doesn't fit what I think is anybody's common definition of a mural. It was actually painted on wood and then the wood was applied. So it was art, maybe it was graphic, it was a display, but it wasn't a mural under the sort of Merriam-Webster definition, which is you paint it right onto the surface. And so that didn't have an impact in the case, but it just goes to show that, definitions, you can really start to get into semantic battles if need be. But if you define mural and then you exempt murals from the sign code, then you're going to certainly be more consistent with what the Institute for Justice, who was the sort of nonprofit public interest law firm that ended up doing 99% of the work for the Levitt's case on the Levitt side. You'd certainly wouldn't be offensive to their view of it. And that would be one of the bigger potential opponents out there in the legal world, because what they do is they do sort of just kind of look in the news and anything, and they challenge sign ordinances all over the country. It's just part of their mission statement, and other things that have constitutional component, of course, with free speech. But they have sued towns in many states over sign issues. So in my way of thinking, if I'm thinking about efficiency and cost saving and not having problems, to me, if I felt like I could satisfy them, then you're probably about as safe as you could be. And what you said, OJ, would satisfy them. However, what that opens up is a Levitt's type situation, where somebody does in fact use it to be a business sign that would not otherwise be allowed because it is too many or too big. And they say, well, it's a mural, so it's exempt. So I get to have that mural and also my 5 other business signs or whatever it may be that makes it too many. So that's depending on your viewpoint, that's the potential negative consequence to that, is that it would allow certain businesses to evade the spirit of what you're trying to do to limit those types of signs by creating a mural. One of the things that I thought of in going through this is there was this section in the ordinance that essentially allowed kind of a swap of sorts. I'm trying to remember what exact section that was, but it allowed somebody to be able to swap something out for signs. And so if you said that murals are exempt, but if there's an entity that's, using signs, that it would count as one of their signs, you might be able to do something like that, so that you allow the sort of artistic expression of a mural, but don't allow somebody to sort of use that as an extra sign that shouldn't otherwise be allowed to. So that's a hard balance to strike, because you're striking the balance between the safety and the sort of visual distraction and the sort of natural aesthetic that the town of Lincoln, at least in part, relies on for its identity and its tourism economy, with the rights of artistic expression and free speech. So that's something that I would say would require a decent amount of thought and thinking on exactly how it's worded to strike the balance between those two things. And I'm not saying that person to do that would be me. And the reality is, if any town that was going through this issue authorized me to do so, I'd be more than happy to pick up the phone and call the IJ folks and say, look, I'm working with the town. We know you have your finger on the pulse of these issues, and we want to run this by you, and know that if you would sue my town based on this ordinance. And that might sound silly, right? But it's one way to get a potential opponent's perspective. And if they say yes, you can go with it anyway and hope they're bluffing, or you can amend it. So that's just one of those. And in doing that, I would never disclose the town. I would just say, here's some language for a potential sign ordinance change. Give me your honest Institute for Justice opinion on it. So there are ways to vet changes that would hopefully keep any town out of litigation.
I mean, you're never gonna keep everybody happy, and that was the reason for that question, James. So no two people like the same thing, so you're really not worried about the content or what might be in the sign or mural or display or graphic that is pleasing to everybody. It's the ones that someone's gonna take objection to. And,
Right.
and to me, I'm a little confused because I thought you said that, you know, a wall is content, a blank wall. So if that's the case, then if you're trying to discern a distinction between a mural and a sign, you're looking at an artistic display and that's content, and you've made a distinction based on the fact that it's artistic display. So,
Yeah, I mean, I agree. And so that's part of the reason why I said to OJ that would be the best way to attempt to get around that, but it's not without its own pitfalls. So one good way to talk about this is again, back to the context of the Levitz case. In that case, one of the things that was done and discussed is how the ZBA had handled other similar situations in which something was deemed to be a sign that was not compliant with the code. One example was Adventure Suites. The decision there was that it wasn't a sign, it was an architectural feature, because Adventure Suites is a hotel that has themed rooms. And so the outside sort of looks like an old-timey town. And so you've got a blacksmith sign and a church sign and a fire department sign, that none of those things are there. So they're not obviously advertising anything real, but they were expressing content and they were artistic. And so that decision was that they were an architectural feature or design element, not a sign. Trash cans that were ice cream cones that were at an ice cream place were deemed to be signs because they were depiction that were identifying information. Those trash cans are still there. A mural of a farm on a farm stand that was agricultural was deemed to be a sign. One of the things that happened close in time to the trial in the Levitz case and the decision is that at Settlers Green, which is an outlet mall, there are a number of murals. One are these large wings that within it have a number of sort of consumer items: shoes, purse, lipstick, other things you can buy. And so one of the ideas was that, well, because it shows what you could sell and it's advertising, it's a sign. In the same mall, same outlet mall, and it's an outdoor outlet mall. One of the things that's there, and it came from a library or museum originally or something, is this what is called the New Hampshire Heritage Mural. And it's a relatively large mural, and it depicts sort of a chronology of important aspects of New Hampshire state history. And so does not, I think everybody agreed, did not in any way advertise anything to do with any commercial aspect of Settlers Green, and really wasn't commercial at all. The town of Conway ZBA, through the process of dealing with that, allowed that one to stay, but said that the wings one had to go. And the federal court really didn't like that, because when you start to get into regulating depictions and graphics and murals, the idea is that whether it's commercial or not, you need to treat them the same. There's at least some thought in my mind that if the ZBA in the town of Conway had said, you know what, we like the heritage mural, it's wonderful, it's great, it shows important things of New Hampshire history, but you can't have it there. You can move it inside somewhere for everybody to see, because it's not a sign once it's inside and not sort of in the public view. The case could have gone differently, because there would have been at least that one example where the town treated a non-commercial graphic the same as the commercial graphics. The point being that if you're going to allow murals, you might have to allow murals as business signs. But if you're not going to allow murals, then you can't allow them whether they're business or residential. So you end up throwing out a little bit more, you're not I'm not to say this throwing in the baby out with the bathwater, but something has to kind of give when you either have to regulate more non-commercial stuff or allow more leeway for commercial stuff, or else you will inevitably go one way or the other on content. You will either overly restrict one way, or you will not restrict enough on one side, which then will be deemed to be discriminatory. So you have to treat, in my opinion, based on going through this Levitz case, you have to treat all depictions the same. So in theory, a store could have a quote unquote mural as a sign, meaning painted on the wall. That would be okay if it's the right size for the store. So, you know, if they want to make their, instead of making a traditional sign, they want to do an artistic, you know, depiction of a hamburger or a piece of candy or ski supplies. Great, but it can be a mural. It just got to comply with the sign dimensions and requirements and locations. And obviously,
your answer to my last question, number 5, which is, can you prohibit murals? And not that I'm looking to prohibit them, because I think murals, artistic expression is nice, but it seems to me like, due to the case, and it's going to be really hard to try to force any or make comments on any type of a mural that either someone doesn't like, whether it's within the town itself or, you know, as governmental or private.
Right.
So it is restricting it to say no murals. Is that maybe the best way to go until we can find a way to, until it gets further down the road and maybe some more research can be done, or more cases happen, or more, you know, it just seems like once we allow them, and I don't know if we can stop allowing them now, so that's probably the first question too, but I mean, can the town of Lincoln say no murals? I mean, we can't even get our sign ordinance squared away. You know, I mean, so
to me, with murals, it's kind of all or none. It's when you start to get into try and micromanage them that you will have a more likely bigger problem. So you could either be safer with the OJ approach, which is exempt them, or your approach, Paul, which is you can't have them at all. I think the safer one would be allowing them than not allowing any murals at all, because not allowing any murals at all is more likely, in my view, to run afoul of free speech. Meaning, if I wanted to put something on my wall that expresses some idea, and you tell me I can't do it because it's a mural and no murals are allowed, I'm more likely to have a case than if I'm allowed to do it and everybody else is allowed to do it. But the reality for me is all or none. When you do all or none, and you're not, well, this in this case and this in this case, whether it's all or whether it's none, everybody's being treated equally. Anybody that would be a potential content producer is being treated equally. If there's no murals, then it's no mural, whether it's political, religious, business, or nothing. And if it's any mural, then, you know, obviously there's no issue there, because nobody's judging any of the content. It's all just allowed. So hopefully that makes sense, that answer. That's sort of saying, well, it could be either extreme. I think either extreme is safer than trying to figure out how to split the baby. I think you can probably figure out a way to split the baby that ultimately would be legal, so to speak, but it requires probably a decent amount of overhaul to what you've currently got.
and that's what my question was for, was trying to give the town a little more time. But I mean, if you try to restrict either a display, a graphic, artistic displays, you're restricting it based on, if the town's to say none, we would be restricting it based on content. And how can we do that? That's more kind of like my question, because
yeah, that's why it's the more dangerous of the two options, in my opinion.
I mean,
the restricting altogether.
but if you allow it, you run the risk of upsetting all sorts of people, because someone does an artistic display or graphic that upsets people and they don't like it.
Right.
Isn't that the same?
People not liking artistic expression will never be a winning argument in a federal court.
But it's not, what was art to one may not be art to another, like you just said, swastika, you know, pride flag, you know, white supremacy, it could be anything. And so by
Yes,
not,
that is,
by not being able to at least look at that and have some sort of guidelines that you could say, no, we don't want that in the town of Lincoln, it doesn't seem fair.
But isn't that the same with a sign? We give someone approval to put up a, whatever, 4 foot by 6 foot sign. They can put any of that stuff on the sign, correct?
They can bring it to us, yes, yeah, they can make out a,
They don't bring it to us.
no, they can make out a sign request and. I mean, I suppose I'd have to look at the ordinance to see if they can be refused, but now based on the Conway case, maybe it can't because of the content. So, I mean, maybe you're better off not to have a sign ordinance. Really, because you can't stop people, businesses or otherwise, from putting something up. You know, maybe you could just regulate the size, the location. But, I mean, does it make sense to based on the court's findings to do some of that?
so, one thing I'll say, Paul, in response to your questions and your thinking and concerns about this is part of the reasoning in the court's decision in Conway is, so in any constitutional challenge, for a government to take any action that's regulatory, they have to have some reason. And this gets into the sort of constitutional standards and the scrutiny, whether it's intermediate scrutiny, heightened scrutiny, strict scrutiny, etc. And so the point, as simple as possible, is if you're going to take action as a government to restrict anybody's behavior within your town, you have to have a legitimate, in some way legitimate, how legitimate and how significant it is, that's up for debate depending on the type of case. But you have to have some form of a legitimate reason to take the regulatory action. And then the regulatory action has to be related to it. So what the judge said is, okay, Town of Conway has these legitimate reasons for sign ordinances. Safety, because we don't want signs distracting people. We don't want rundown signs falling on people. We don't want signs causing any level of a safety or distraction hazard. And two, you have a valid reason, valid in New Hampshire, especially through state Supreme Court cases that the federal court says we will go with that, for the preservation of natural aesthetic beauty. So obviously aesthetics is content, but what we're saying is not that one thing is prettier than the other, but we don't want signs everywhere that therefore block the views of our mountains, lakes, rivers, and streams. Those two things are good. Those are legitimate government reasons to enact a sign ordinance. But what the judge said is, because you only would have said Levitt's needs to go away when it's on a bakery, and not if they put the exact same sign next door on a farm stand, then you are not narrowly tailoring your enforcement, because that sign, if it's unsafe or blocking a view, is equally unsafe or equally unblocking or blocking a view, regardless of whether it's on a bakery or a farm stand. And so if you're going to enact a regulation and it's about, and yours are safety and natural beauty, preservation of natural beauty and aesthetics, then saying somebody can't put a mural up because you don't like the way it looks does not, in and of itself, in any way advance either of those two objectives. Because murals aren't unsafe if it's not distracting, because it's never going to fall down. And if it's just because you don't like it, then that's not actually related to the natural aesthetic anyway. Because if you say, yeah, it can be blue and pink, and that doesn't somehow get in the way of our natural aesthetic, but if it can't be black and white, because that would, then the judge will say that's not rational. And in fact, he very strongly worded his opinion and said is not logical. It's deeply illogical to say the exact same thing in a different location is more unsafe. So that's why, especially for murals that are very rarely going to have a structural safety component. Certainly, if you paint a mural somewhere that looks like one of those weird 3D murals that looks like it's a tunnel you could drive through and it's a building and you crash into it, yeah, that's a problem. But if it's nothing like that, you're very likely gonna never succeed that it's a safety problem. If it's on a road and it creates any sort of distraction or hazard, maybe, but no other reasons probably will work based on the outcome of the Levitz case.
So Jason, we have someone else that has a question, Marguerite?
Yeah. So I checked out some other ordinances from some other towns, and they defined murals as two separate things. There was an artistic mural and there was an advertising and commercial mural. And I was wondering if we could go that route, like kind of exempt murals so they could go anywhere, but if it's commercial, it just could, and it could be really specific, like no logo and no business name. But other than that, it could be a go.
You know, I think maybe OJ had mentioned this idea of an artistic mural in one of his questions. And I like that idea a lot. And I kind of give some thought to that idea and I looked it up. But the reality is, if you have artistic murals and business murals, you are probably going to put yourself exactly in the same place of the Levitz case, because that's what the judge said. It's a depiction, and the town only saying it can't be there because it's a business mural, because it shows bakery mountains as opposed to real mountains. No good, doesn't work. So I think that the defining an artistic mural and an advertising mural would actually be, at least based on the outcome of the Levitz case, my first instinct is that'd be more problematic, because you are highlighting that you are treating different content differently, as opposed to just say, so that's based on the Levitz case and some of the research I did when I saw OJ's question, that to me, though it would be a wonderful idea, and I think there are ways to work with it. If you say artistic mural is blah, 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 and a business mural is a mural that advertises business, and so they can't do it, you have the same outcome as in the Levitz case, is my opinion.
Hey, Jason, could you restrict murals, if you could, based on safety, location, and size? Could you use any dimensional qualities or safety, and restrict them at least on those three premises, so you would be able to have some control over how big they were, where they were located, whether they were safety, things like that? Could you do that?
Yes, I think that is one of the easier things that I can say yes to. You pretty much always, as a government entity, have the ability to regulate time, place, manner of speech. Those are the sort of constitutional buzzwords in a First Amendment case, which are very similar to the ones that you used yourself just now. So place and manner obviously deal with, location, and the manner sort of safety. Obviously, a mural, the manner of a mural is always the same, if we're applying a dictionary definition, which is graphics painted onto a surface, generally an external wall that everybody can see. But if you say, we allow murals, but we only allow murals as long as they are within the same size parameter as whatever signs have to be, like the biggest a sign could possibly be on a business in a given zone. Then you can have a mural up to that exact same size. If you do something like that, I think you probably are going to have a decent chance of prevailing in face of a legal challenge, because you were saying we're not restricting the content, and we're not going to determine whether you're a mural or a sign based on anything. We're just going to look at it, and whether it's a sign or it's a mural, same size. So
further, my question would be, if you, on a safety aspect, if someone painted either a 3D swatch sticker or just a swatch sticker, and people driving down the road were looking at it, and it was big, and it caught their attention, and became a safety issue, are you able to control it that way? Some of the graphics that might attract people's attention and make a safety issue?
I think you're going to have a decent argument that you can make, that if there's a giant swastika that anybody driving on a public road is going to be able to easily see, and it will, in my opinion, more likely than not, for a variety of different reasons, good, bad, or indifferent, cause distraction, that you would be able to say, based on the distraction of, now, it's distracting because it is so polarizing, right? If it was just a cloud, arguably it's not going to be as distracting. And so there is inevitably a little bit of a content piece there. But if the idea is, nope, this sign is dangerous for a variety of reasons, then I couldn't sit here and guarantee that you get all the way through and a judge in a federal court doesn't ding you for it. But my best sense is that you have a much better likelihood to prevail in that type of a situation than you would in the Levitt situation. Then in obviously Levitt's case, they didn't prevail, the town didn't prevail. But even with that extreme example, right, I couldn't guarantee it. But I think if it's big enough, then you're going to be okay anyway, because you could say it's too big.
Right.
And if
Well,
in
if
the,
we move
let me say one more thing,
ahead.
Paul, real quick. If in the initial violation letter from the town to Levitt's, if they had said this conveys information, if they'd have basically just quoted the definition of the ordinance and said, we see this, here's the definition of sign, this meets that definition, is too big, they would have probably had a relatively significantly greater chance of being successful as well, because there would have been no history in the record that it was a content-based decision. The ZBA, of course, didn't ultimately end up helping because they're the ones that said, well, if it was across the street, it'd be fine. And the judge really, really didn't like that. So if it's a big swastika and it's bigger than a sign is allowed to be, or any mural is allowed to be, whatever we want to call or define it, then you just say, we've seen your graphic at such and such an address on such and such a building. According to the zoning ordinance, it meets the definition of sign, mural, whatever. And according to the requirements in the ordinance, it's too big. So that's the biggest piece of advice that after the Levitt's case, I think I would give any town is just say it's too big. Don't say anything else.
So we have two other people that have questions submitted to you. One, OJ, you had something more you wanted, or did you get anything?
I think I was,
Were you satisfied
Yes,
with
I think
the
all-
discussion so far? You think it answered your questions?
Mhm.
And Sue Baruby had a question as well.
I think hers was sort of answered. Hers dealt with defining sign and mural in a way that would be legal and not discriminatory. I think you could do that, but as I said before, just having those two definitions without sort of other pieces would not in and of itself, especially depending on how they are enforced, save the day. You'd have to make sure the enforcement is also not discriminatory.
So if someone came in today then and wanted to put up a mural in the town of Lincoln, could the town of Lincoln, how would the town of Lincoln go about giving them advice on what they could or couldn't do?
Right. So
So because the reason why we started this was because we had, I think Western White Mountains came in and they wanted to start doing some artistic displays, murals, sculptures, paintings and stuff like that within the town. And we really had no advice for them, and you recommended us waiting. So now that this case is over, what kind of guidance can you give us as far as that goes?
Yep. So the guidance would be that when they come in with their application, whatever it is, that I would look at it, look at the application, look at what they're planning to do, only to determine if it fits the definition of a sign. Because if it fits the definition of a sign, as it currently exists in the ordinance today, then it would be, in my opinion, not based on the content, but based on just that it meets the definition of a sign, regulated dependent on what zone it's in. So whatever the normal sign regulations on size in a zone would apply, and it's not as broad, the town of Lincoln's definition that is not as broad as the town of Conway's. Just the town of Conway's had some wording that was basically if it conveys any information of any kind, whether commercial or non-commercial. And that's what the judge was saying when he was pointing at the white wall, is does that convey information? I think it does, which everybody can have their opinions on whether that's extreme or not, but the judge deciding the case, that was where his head was at. So I just want to read this out. It might seem silly, but I want to read this out loud because everybody can sort of think of this when they think of the concept of a mural coming in. Any object, device, display, I think mural would fit into display more than object, device, or structure, or part thereof. I think in theory, mural could fit or part thereof because once you've painted a wall, it is now part of the structure because it's the wood or whatever material. Situated outdoors or indoors, used to identify, display, direct, or attract attention, which certainly a mural would attract attention, but then to any object, person, institution, organization, business, product, service, event, or location by any means. And so if there's a big mural anywhere in town, it will attract attention to that location where that mural is because people will look at it. They may want to go up and look at it more closely depending on how intricate it is. So my opinion is that it would be hard for a mural to not meet this definition, depending on certain things, of course. But it will be a display and it will attract attention. People wouldn't even make it if it wouldn't attract any attention and nobody was going to ever see it. And it's by any means, including words, letters, numbers, figures, designs, symbols, pictures, colors. So a white wall, right there we go with the color white. Is that signifying innocence? Is it signifying clouds? Who knows, or nothing? So the analysis is twofold. Is it a sign, this application, for anything, any kind of display? Is it a sign? And then if it is, apply the sign criteria. If it's not a sign, and that is the final determination, then basically you can't do anything unless it is obscene or hate speech that is inciting violence or an actual threat.
Can we use those terms in description? No. I think we lost. Are you there?
Frozen, yeah, he's
You're frozen inside.
still, I think, all frozen.
He's just a mural. Do we lose our,
I'm not sure what to do about it. We start over? See that okay up there? Wait.
We're
We
still
can hear
here.
you guys, no problem. I think Jason just must be stuck or frozen.
Oh, good,
Can
thank you.
he,
Yep.
he hear us?
Okay, Jason's gone now.
he's gone, he's gone. I'm trying to get back.
Yeah.
Must have had time. We'll give him another minute to see if he's coming back on. Did anyone else have any other questions for Jason though, other than?
I had something.
Okay.
So, you know,
Well,
if,
he's not on yet, I just want to make sure, yeah. If he doesn't come on in a few more minutes, then.
is that a federal regulation?
There it is. Are you back, Jason?
I'm back. I could hear you all and see you all. Obviously, you couldn't hear me, and then it just cut. The whole meeting on me just shut. Anyway, I'm back. Can you hear me?
Yes,
Yes.
yeah, we can. Can you hear us?
I can, yes. So
Okay,
the
so
last
we-
thing, Paul, that I
ahead.
heard from you is can we use those terms? And my follow-up was I just wanted to make sure I understood which terms you were talking about.
The terms of, they would incite violence, I think you said that was one of them. There was another one you said too.
Yeah, what I would actually recommend if you're going to deny something that you do use some of those buzzwords. And what I can do is include those things that a town has more ready ability to just ban altogether.
All right, so we have another question from Margarita.
So, in the current ordinance, you know, a business can only have so many signs. But now if they want a mural, they would now, if that's considered a sign, they would be breaking the ordinance. Also, with the wall sign, it has to be less than 20% of the wall, where a lot of times a mural is 100% of the wall. And, so I don't, I don't see how we could be both without a separate definition. With the current ordinance that we have, if we were to allow murals.
Did you understand the question, Jason?
I think so. I'll kind of repeat it back, which is how, if we're allowing murals at all, how do we do it without a separate definition?
Yeah.
And so if there's not a definition of mural, then the only definition, either you just say, we're gonna just sort of, our view is it that murals don't count as signs at all, ever, no matter what anybody does, and so murals are just exempt, and so we're not gonna regulate it, or you have to make the determination of whether it fits the definition of a sign. The judge said in the Levitt's case, by the way, that that was a sign. And in fact, he said it's a commercial sign. So that was not the basis of his decision to decide in the bakery's favor. It was a sign. It was a commercial sign. The town's ordinance is probably good. The town could probably even enforce against Levitt's the next day. It was one of the more narrow legal decisions that I have ever read in my entire career. And it was basically just because since the town only didn't allow commercial murals, it was content-based, and they discriminated against commercial entities as opposed to non-commercial entities. It's totally fine for the town to look at a mural and apply its definition of sign to the mural. If there's a separate definition of mural, which I think is absolutely fine to work towards and have, just because one of the answers I gave is that those two definitions in of themselves don't solve the problems. That doesn't mean don't try to come up with a good definition for mural. But when you don't have one, and a graphic comes before you, and you have a definition of sign, if it meets the definition of sign, then you can choose to either enforce the sign ordinance against it or not. There doesn't need to be anything else that exists. And in the Levitt's case, totally fine with that. Again, if they'd have said, this meets our definition of sign, it's too big, you have to take it down, that Levitt sign would probably be down right now, unless there was some other deal, because the court would have ruled in the town's favor. I can't guarantee that, of course, because that's revisionist history. But based on how the order was written, I'm high level of confidence that that's how the outcome would have been. So here, if a business comes and say they're allowed to have 4 signs, and again, I'm just picking a number because who knows, and they say they also want a mural, this gets into that trade-off thing. You could say, yes, you can have a mural, but it has to meet the dimensional requirements, and you got to get rid of one of your other signs because it meets the definition of a sign. And if that's what a business wanted to do, have 3 standard traditional signs and have one of their other signs be a mural, I think that would be totally, absolutely fine under the current ordinance. If it meets the definition of a sign and it's a mural and it's a 4th sign and you can have 4 and it meets the size requirements, fine. If they want the mural to be a traditional full wall mural, you're not going to be allowed to do that probably if you say it's a sign. So that's a sort of philosophical type decision that the town would need to make. I think with the ordinance you have now, you can apply the definition of sign. If somebody doesn't come with an application and you drive by and you see a mural on a business, or on a residence actually, and it's if it's a display or an object and it's attracting attention to any object, person, institution, organization, business, product, service, event, or location by any means, then you could probably cite them, as long as you're doing it based on that it's a sign and it's too big or too many.
Could we change the terminology to displays and graphics versus murals and signs, and or is that just? Because that way you're not finding murals, you're just using graphics and displays.
So that's a very interesting question, because that's how we ended up talking about it in the Levitt's case. It didn't matter whether one person called it a sign or one person called it a mural. It mattered whether the display, whatever it was, met the definition of sign. So if you changed the sign ordinance to a graphic ordinance and you had defined definitions for graphics and displays and signs and murals and everything else, you could probably do that. You could probably just define but I think you're starting to get far afield from the standard ordinances that it'd be an experiment that would be, I would be nervous to go so far away from sort of the traditional way of sign ordinances, even though obviously it didn't work out so well in the town of Conway's favor based on the outcome of the Levitz case. But I mean, it's a very interesting idea.
Steve?
Jason, did Mr. Levitt think anything about when he took his mural and put it on his donut box? Was that a mistake or?
In the end, not much of one because he gets to keep his sign. But the judge did say in the decision, he was cagey in his decision because he only made an actual definite decision on a couple points, and then other ones he sort of assumed without officially deciding, and probably this and probably that. Judges like to limit their decisions to only what they have to decide and not like decide things that people didn't actually ask them to decide. So this decision was no different. That said, that box was an exhibit in the case, and the judge did decide, and actually there's a footnote in the case that was quite interesting. Let me see if I can find it. I apologize. I had it up just because, well, I thought I could maybe refer to it. So it's just a footnote in the decision. And it talks about whether it's a commercial sign or not. And it says the court readily makes this finding without reservation, despite the plaintiff's counsel, and that was IJ on behalf of Levitz, generally unhelpful insistence, especially early in the litigation, and the plaintiff's, that's Sean Young, dubious testimony that the display is a mural, not a sign, solely intended as an artistic expression. So the judge, in my opinion, did not for 1 second buy the argument that this was not intended to be related to the Levitz Bakery business in any way and not to serve any commercial purpose. The donut box supports that conclusion, in my opinion. But the manner in which the regulation occurred ended up sort of trumping that. The judge basically did say that the town would have the right to regulate commercial speech. More and more through the cases, including the United States Supreme Court, commercial speech is sort of becoming equal with non-commercial speech as far as First Amendment. It used to be many years ago where it was like this. So commercial speech had far less First Amendment protection. That has only increased over time, where commercial speech has probably 85 to 90%. I mean, I'm just sort of picking these numbers, but a substantial similar amount of First Amendment protection. And so it's not carte blanche for a town to regulate commercial speech, do whatever it was, but you get a little bit more leeway for sure. And in the Levitz case, if it had been handled that particular way, then it could have changed the outcome. And so if commercial speech is an aspect of a town's ordinance and how they're dealing with things, you still got to be careful, of course, because again, as I said, commercial is starting to be on almost equal footing. Then you could probably work in a little bit more ability to regulate commercial speech, including anything that might meet a mural definition if you have one.
Is there anyone else on the board that has any other questions for Jason? No. Sean, did you have a question?
Probably through you too, behind the house. Is that a sign?
He can't hear you, so we have none.
So like.
This is Sean, our code enforcement officer. He has comment.
My question is to Paul, to you, Jason. Behind the house, is that a sign or is that a mural
On the brick wall,
on the wall? That's,
I did.
I think what you're gonna start to see, those are the questions you're gonna start to have. So I'm just throwing it out as an example. If this is what's coming down the pipeline, what is it?
It's like in the parking lot. If you go into Lahoo's parking lot, like before you go around the building,
Oh,
there's a
one right here.
wall.
Yes,
Yeah, but you're not talking about the actual skier. You're talking about, it's like really fun and colorful.
yeah, it's a big, huge thing.
You talk about the skiers on the side of the building.
No, there's something on the wall in the back.
On concrete wall in the back.
I think it's been there since the early 2000s, something like that. But then, is it art or is it a sign, or this is where the murals are going?
We have a business that has a concrete retaining wall and someone has drawn art on it. And the question I believe from Sean is that a mural? And so I'll let you answer that.
Probably meets the definition of sign under the definition in the Lupo. Doesn't mean you have to enforce against it. Meaning you perhaps could, because whatever that is, draws attention to something, and does so with one of the various mechanisms that define it as a sign. But
It could be unsafe because it is in a travel zone, so, but
say again, Paul?
it's, the retaining wall is, part of a turnaround around the back of the business.
It also has an arrow to direct traffic.
Right.
So now is it a traffic sign?
Yeah.
So the
But I wasn't
definition,
complaining about it, no, right?
No, Like,
There isn't.
It's failure to do something about it, setting ourselves up the same way Conway does.
potentially, I heard that question, and that is one of the types of things that was used against the town, is that they came after this business when they hadn't come after similar things, and so it was unequal discriminatory treatment. So is it setting you up? I don't want to be so harsh and negative as that, but in the future, if there was a case and they say, wait a minute, what about that? You say, well, we don't consider that a sign. And the judge says, well, you're not interpreting your own definition correctly. And so therefore you screwed up. That's exactly that's what happened in the Levitt case. You're not interpreting your own definition equally. And so you've violated Sean Young and Levitt Bakery's constitutional rights by doing so. So
We advise the council not to do anything about it.
say again?
I said, but we were advised under council not to do anything until after the Levitt case.
Oh, yeah, because we don't know what the law was.
All right.
And I stand by that 100%. I don't think, taking, and the other thing is, and this is important always, is towns have the right, and this came up out of a Laconia. I was not involved with it, but I know what the sort of legal reasoning and decision was in a short-term rental case in Laconia, where they engaged in what was argued to be selective enforcement. But they said, no, it's not selective enforcement. We're engaged in complaint-based enforcement. We're not running around policing every short-term rental. We don't have the capacity, the time, the money to keep track of short-term rentals in Laconia. There's too many, and some we know, some we don't know, and some are handled differently, and we're not going to be searching Airbnb every day to figure out if there's a new one. And so if somebody complains, then we'll enforce it. So you can always feel comfortable with complaint-based enforcement. If somebody were to complain about that as a sign, you would then potentially have to make a more difficult decision. One of the things that the definition of sign in the Lupo does not have, that does exist in a number of different municipalities in New Hampshire and beyond, is an aspect of it being visible from a public way. And the indoors piece is interesting too, because a lot of ordinances wouldn't regulate anything that's just inside. Like you go into a restaurant, like you go into an Applebee's, yikes, they can't have that anymore. Those are all signs under the Lupo. And so, because it's indoors and they convey information and attract attention. So the idea of where it is, whether it's a sign or not, you can work with. So if it's on the back of a commercial building and there's no way for the public to go back there in any way, and the only thing back there is their dumpster, I think you can safely say either A, it's not a sign under our ordinance. It doesn't say that now, but it could be amended to say it's not a sign, or it's exempt. And I apologize if there is an exemption for things that aren't visible from the public way, and I'm just not remembering it from my reading of it. But that's one way to deal with those types of things, is if nobody can see it, then it's not a sign.
So to draw some conclusions here tonight, or where we go from here. You're planning on sending a memo, email to Carol and Karina with some suggestions as far as how we might address changes in the loophole regarding displays or what wording might allow us to have some sort of review over it.
Yeah, what I'll do is that, but also flag anything that exists that's not specifically related to the mural question that could have similar implications on being content-based and therefore, maybe arguably not constitutional and causing problems. So that'll be one section, and then the other section will be potential changes to deal with this mural issue.
Do you have any other suggestions that we want us to consider? Or talk about prior to you doing what you're planning on?
No, other than OJ had asked a question about other towns. Portsmouth and Dover have aspects of their zoning that encourages murals. And so that's just different examples of ways that people go about doing it, or municipalities go about doing it. Some towns are going to want more murals than others, or allow it or not care. Some want to avoid, certain graphics or depictions or structures that just block all of the scenic views that people come to the town to visit and see and enjoy. And so I guess the bottom line is striking the balance is unfortunately difficult.
You're never gonna please everybody.
Correct. And so at the end of the day, if there was to be potential changes to the Lupo relative to the sign piece in any way, the planning board can absolutely prepare a proposed amendment and get it out there for the legislative body to rule on. And if it's been well thought out, well considered, and then the legislative body approves it, then you feel like, hey, we're pleasing as many people as the reality of human beings living together can possibly legally allow. And I know that might sound overly sort of political or philosophical, but the idea really is that when people live in groups, there's a social contract, and we all give up some freedoms for protections. And that's just how democracy and the United States government works. Some people want none, some people want limited, and some people want as much as possible, and they're willing to give up more freedoms for it. That's obviously getting into political beliefs and spectrums, but a town governing body with the advice of votes from the legislative body, ultimately that's one of the biggest jobs you do, is you balance people's individual freedoms and property rights with the greater good of the town as a whole. And it's a thankless job. But I think
Okay.
doing it.
OJ's question.
Jason, does Portsmouth and or Dover, in the ordinance define what a mural is separately than a sign? When they say
I
that
think
mural, is it different than a sign?
I think Portsmouth might, but what makes some sense to me, OJ, to send to you guys if you want it, is just because I've dealt with it for a while now, not 100% directly, because Russ Hilliard and Brooke Shiloh were the lead counsel in federal court in that case. But the Institute for Justice has a model sign code. And so the opponent in the Conway case, because again, this is a big part of their mission, they've created this. I think many municipalities would say that this ideological organization's model sign code goes too far, simply because the organization is, I think they're libertarian, which is a political group that does lean more towards individual freedoms, right, wrong, or indifferent. And so a town that is creating regulations, very rarely are those two entities going to see 100% eye to eye. I would argue that it goes too far. You might see it and say, oh, this is perfect. We'll do this and we know we're safe if we just take everything they have. They do, in that model sign code, define mural 100% differently, or not 100% differently, but there's a separate definition for mural. So I can send that to you.
Thank you very much for coming on tonight. Appreciate it. Gave us a lot to think about, and we'll look forward to your email memo to the town so we can see what, if any, changes we can make.
Sure. Well, hopefully it's helpful. It's confusing. It's complicated. I haven't answered every possible question there is. I know that, but I will get the memo and hopefully that answers and addresses even more.
Well, I think it's a start. It's a good place.
Yeah,
to start.
100%.
Thank you again.
Yeah, thanks,
Very
Jason.
welcome. All right, I'm gonna sign
Yeah.
off if that is okay with you, Paul, and the
Yep,
members of the
that's
board.
fine. That's fine.
Okay. Well, have a good night, and it was nice to chat with you all for a while.
Okay, we'll continue on to item B, which is the public hearing continued from the May 28th planning board meeting in regard to converting the vacant lot at the Heights to a 28-unit residential condominium building. You gentlemen are here to address this, I'm sure. So before we start, Carol, I'd like to recognize Carol because Carol's been sending out stuff to us and she has concerns. Comments, I guess, that I think she probably would like to make prior to starting, so you'll know.
Well, I think they,
You're all
I would like-
quick microphone, I'm sorry.
I think I've sent everything to Scott, you know, everything that I sent. And you all have a copy of the memo that I did just asking about the walkway structure that was in a 15-foot side setback area. The retaining wall, maybe or maybe not, I don't know for sure. It says a 2 to 8 foot high retaining wall. It's in the setback area. And there's a 2 to 9 foot retaining wall that's in it's that front setback area for both the subject block and the lot next door with the tenants. And then we also want to talk about the height. So
There was the height and there was also the architecturals didn't show
right,
the
we're looking, we're kind of
detail as far as room sizes, how many bedrooms, stuff like that. We didn't receive, the town didn't receive anything like that. It was a general overview as far as looking at it. Not much detail. Then there's also the ADA parking concern. And the amenities, whether they're gonna be used for just the heights or if it was gonna be used probably amongst the South Beach Homeowner Association. And then the AOP and wetland. AOP and wetlands. Can help comment to that. Good evening.
Scott Kelly from Longfellow Design, like that, so the LLC, and working in different over, and then, Horizons Engineering. So why don't I start with just kind of a quick update, you mentioned AOT and weapons, so why don't I just update you quickly on where some of the other things are, and then I'll put back to Carol's comments, and some of your other questions. AOT has issued a permit, just within the last week, 10 days, so that permit issue. So, we had received a comment from DES Weapons, which Horizons responded to back on July 10th. And they have 30 days statutorily to respond to that, so that will bring us to it's 10 approximately, that they would get back to us. So because of that, I'm not looking to close the hearing tonight. I think it makes sense to leave it open till we hear back from Weapons.
So you're not planning any construction or anything like that prior, you know, you didn't want to get going, you're cutting trees, something like that.
No, I mean, right now, obviously, we do want to advance to approval as quick as possible, only because for a building of this size, you know, we have to go through a lot of back and forth with MEP contractors, electrical contractors, elevators, companies, all that kind of stuff. And we're gonna do that all through the fall, through the winter, not break ground till spring. But obviously, we'd still like to advance and get all the permits in, so that we know kind of have what the final steps are. Guess I can start where, why don't I start with Carol's questions on the variances, and I'm gonna go through that again and have up there. Look at that at the same time. So I took the current site plan and I highlighted, but just quickly highlighted and read the areas that Carol had identified in her memo from today. So just quickly looking, we'll go by number. So number one is, so along this side of the building, we have a set of stairs and platforms so that pedestrian activity can walk from back of the building all the way down to the side of the building, and then come down to get, you know, over to the tent or to the nest or over to the ski area. This area here is the area that Carol has called out. This section of the stairs that's in the side setback. I would argue that's not a structure. I don't know why a set of stairs is considered a structure. So I guess we can debate that. That it's not a wall. It's not defined in the regulations that Carol shared as something that's considered a structure. So I don't view that as an issue personally. So we can go through to talk about each one, or I can talk about all the different areas. However you like.
Trying to find the drawing that Carol had. Give us a copy of one that's colored.
Yeah, it's in the memo, so.
Can't find the one that. Half by 11, so.
It'll be right before.
The memo was all
Perfect.
pictures in the back.
Oh.
They come together.
Go ahead, I'm sorry.
Okay, so number two is this small portion of wing wall that comes back from Henry's fire parking space. And that just extends into the front setback by a couple feet. That's an easy revision. You just pull that wall back. Figure say not have that setback. Okay. Ready to do it.
You know,
So you're saying that this one here, you don't. We'll start off with the bigger plan now. It's where the stairs are. You're saying that's not a structure, not retaining.
Oh, it's a set of stairs.
And how high is it? The wall?
No wall. There's no wall, just up where it is. So you're just going up the set of stairs built into the embankment, grade goes up to the edge of stairs along the side. You can kind of see the proposed grade, so it's
The grade ties into the side
sides
of
of the stairs.
so there's just steps, there's no structure there, there's no set of stairs in the bank.
I'm just saying, we treated everybody else as, you know, the decks and the stairs and all that.
It's not a deck, it's not made out of wood. That's not one.
Basically saying it's for a case. Pretty much.
I mean, the stairs would be concrete. Okay, but they're built into the ground and the grade blends right up to the side. And they're not attached to the building. So it's not part of the building.
What is our, I have to look at our ordinance and see.
Well, I read in the memo.
Okay.
Okay, so, structure. Says, anything constructed or erected to a fixed location on the ground or attached to something having a fixed location on the ground, including amusement devices. Structure for floodplain management purposes, also include the wall or the building of gas or liquid storage tank, principally about, as well as a manufactured home. And the word structure includes all types of retaining walls. That exceed 4 feet in height, you know, there's a section on that. And permanent structure, a building or structure that's intended to remain in place for a period of more than 180 days in any consecutive 12-month period. That includes but is not limited to a tent, greater than 400 square feet of dirt, plus a shipping area, a floater, a building made of fiber, plastic, or some other temporary material, the fiber or plastic quantum height, or any other temporary structure gives the appearance of being temporary or short life expectancy.
Well, Scott, let me ask you, is there a way to change that one portion so it doesn't come into the setback?
Yes.
You want to do that?
Yes.
Okay, we'll take care of that. We're just gonna go at it one at a time, so.
There is enough room that we can slide that over.
Right.
So that I think we would probably keep the same,
Couple different angles there.
the same orientation, but just slide it over so that beginning of the stairs.
So not to pick at it, but I do have a question fundamentally on this, because if you build a building outside that meets the setback criteria that's on the street and you got 15 feet. And the street is 4 feet lower than the building, and you have to get access to that building. You need stairs to get up to that. Could be right on Main Street here, could be anywhere. You have a front setback, and stairs are, I would view not stairs not as a structure, but as a improved surface that acts as a conveyance, right? Meant for human pedestrian traffic. Not a structure. So I understand the retaining wall being called a structure because that's clearly an erected structure. But what the determination here would preclude anybody from getting access to their building off the street with a walkway. If there's any grade change.
Button the building right up next to the setback.
Well, it doesn't matter, but that's not my question. My question would be,
Well, but I guess she has a point. I mean. If you're designing something, you typically would try to design it to stay out of the setback, no matter what was there, just so you wouldn't have the issue coming forward. You know, and if that's all you had, if you only had that ability, then you would have what I would consider a hardship, because you have a limited amount of space and you needed to have your stairs going, but like a house on Main Street, as you described, and the grade changes, they kind of have a hardship because they don't have any land really to get in there except for their setback, and they would need to get into their house. Here, you know, you can make an adjustment so it's out of the setback. So for me, it's a matter of, do you have that ability to do that? And it sounds like you do. I mean,
Yeah, I guess for the record, what I would say is I disagree that stairs need to comply, but because we can accommodate it, we will accommodate it. That's what I would say.
I think that's probably.
And I'm only concerned in the context of not tonight, but another,
Something else.
another.
I mean, we can.
Nothing precludes you from having access to a building because of grade or something like that, and it's in the setback, I think that,
But you started with a bare piece of land.
no, I understand that, and that's what I'm saying, they have that ability to make that change, so, and they're willing to make that change, so. That they will change,
Number two is an easy change. We'll just, shorten that wall, so it's outside of the front setback. Right, that's this one here.
Yeah.
3 and 4, that is the same wall, but it encompasses 2 parcels, so Carol broke it into 2 different parcels for 2 different comments on her list. And our solution there would be, is I'm gonna move the retaining wall into the right of way. We own the right of way. So I'm gonna move it forward. It's no longer in the setback.
So it's gonna be closer to the road.
yeah, you're gonna have to change the drainage,
No, it'll be in front of that swale. Swale that's existing there will still exist.
so you can put it out here. Oh, okay. And the drainage. Because the property line goes is right at the start of the, when I see the header of culvert. To the entrance to that parking lot.
Right, so the wall will go just on the other side of that property line, in the right of way. Setback doesn't apply with it, right?
Okay. You do realize that you will need variance with most of these because they are above the 4 foot mark, the ones that are above 4 foot.
Well, no.
Well, we're
if
gonna
he's
leave
adding
it
this,
in wrong, no.
Yeah, the setback.
It doesn't matter if it's a structure and it's above 4 feet.
We still have to have the engineer. So
Right,
it's a construction
Right.
affidavit, and they'll be engineered, and then they'll be, they'll supervise the.
Oh, yeah, it's an engineered wall, sure, yeah.
I'm sorry, yeah, that's fine.
Yeah, no, absolutely,
Yeah,
absolutely.
no,
So you're gonna remove them all on the setback.
yeah, you don't wanna have to go to CBA.
No, that's fine.
No, that's why we're just saying, you move it out into the right of way, the setback no longer applies.
As long as.
Right.
What you need to do for plowing and. Maintenance and all that kind of stuff, it's not gonna interfere with that.
And you'll move that stairway in there.
Yes.
So that takes care of Carol's questions.
And then it's-
As far as the setbacks are concerned.
Correct.
Height,
So there was also, John mentioned to me that there was some discussion about look at zoning compliance in the district in terms of floors. Okay, so in this district, the definition of what we're allowed for floors is there shall be no more than 4 floors used as living space above or below grade as measured through any vertical plane of the building. This building complies with that, right? So what I did was the graphically show this, I had our architectural team draw this up just for tonight's meeting, right? So this is a section cut through the building. And what you're seeing down here is a lobby section that's not showing this. This out here is the parking lot. Where it's shared with the tenant, right? So that parking lot's out here, it's a lobby in the basement, this section. Next floor up, there's some living units right above the lobby, but that's even with the garage. Then you have 2 living floors above that, and this 3rd living floor has lofts. So there are no more than 4 living floors, in compliance with that, with the zoning compliance, 1, 2, 3, 4.
so what's the,
I can share it with you, I'll leave that one.
so how many floors are you going to have?
there are 4 floors, but the 4th floor has a loft.
So there's only 4 floors.
4 floors with, but yes, there's only 4 floors, but these have lofts.
They have
Right.
lofts.
Yep.
That was similar to
That's what it has.
the gardens up there, right?
But there's not more than 4 through any vertical plane of the building, which is what our ordinance is
Or
worded.
not more than 4 living floors, right? So I mean, the lobby has no living area. That's just an entry to get to the elevators.
Right, but above the lobby.
Yep.
Is only one other floor.
Same plane through the building, right?
It's just
Yeah,
that
that's
plane
right.
is 2, then as you
Yep.
move this way,
Yeah.
it goes to 3, then 4, then back to 3.
And what's the height from the primary use?
So the backside, it would be 37 feet. So we do have to go to the ZBA for a height variance, because the height in this district, the max is 35.
And what would your hardship be for, what would you be asking, supplying for a hardship?
Excuse me, because of the topography, dealing with the grade, like we're basically building into the side of the mountain.
Of course.
Yeah, give it right to the land.
What do you think?
Well, it is. It is.
The height.
I don't see that.
I know that that's not the regulation. I'm just curious as to what size structure you'd be looking at from the road.
Well, if this is 37. Then this is. Probably about 60 feet in front. And only on this, so on the lot side, right, the lot side facing the parking lot, with the deck. And when you're looking at it from Crooked Mountain Road, you're looking at somebody, they go back. So when you're looking at it from this direction, yeah, this is the lot that is happening. That's that height. But this is all the grade with the road, so this is one form of Christine. Christine. From the road, you're seeing this height. Which would be
You're seeing.
like about
49 feet.
49 for the Crooked Mountain. As you're looking at it,
As you drive by.
as you're looking at it from this direction.
Well, Crooked Mountain comes up, right? So the height,
Yeah.
it's 49 from here, but it's less up here. The height road's got a line, the road's going to go.
Look at the question.
We did similar situation when they put the Wood Mountain in. The height restriction. What they did there, they raised the topography in the back by 2 feet to accommodate the legal standing. And if they have the UTV do it that way, or just go with ZBA.
We can look at that.
I'm just trying to say what the opposite was done before.
Yep.
Cause it's larger, at the end of Little Mountain front side. Among us. The slope side, meets criteria. Gives it about slope it up to them.
To the building. Yeah,
So this way here, if the weather's conducive to it, it could get in front of the fire. We're gonna let it go up till reach it.
Well, yeah, that's the concern was the fire department when we originally started this.
That's why this was put in. But Blue Mountain did this, over their building, by bringing the slope up, but not even the height of the table actually. And accommodate the other 2 feet.
okay, so we'll look at that option.
I'm not saying it's mandatory, but saying something you might wanna look at.
Yeah.
So you're gonna have to ask for variance for that.
If it's not, to bring it up 2 feet higher.
Wow. And can you address Carol's comments about the lack of the architecturals or the board definition? As far as the room layouts, whether you're having walkout rooms, whether you're having, so.
So why don't we get you more detailed drawings in advance of the next meeting?
Cause I'll need that for the water and sewer, that be down for the water fixture.
Yeah.
You have a parking counts to be able to verify how many spaces they have, how many room stuff you have.
Sure.
So you'll get us that.
Yep.
What else, Carol, did you have? The ADA parking,
Yeah, so.
that was on Sarah's list.
Yeah, that was, so I'll just kind of quickly read, her response. EK understands and agrees with the approach that we have presented that covers the residential building, that we wouldn't put ADA spaces in the parking garage. If we had someone that needed an ADA space, like that wanted to buy a unit, we could give them an ADA, there's the ability to do that. We wouldn't designate them ahead of time, because then they can't be used towards the minimum parking lot that we need, parking space count that we need. So G and K was questioning whether something should be put outside. They kind of agreed with the approach that we didn't have to put them in the garage.
I understand, but her comment on the latest, bullet points from her said that thus no ADA spaces have been provided, where at least 3, including 1 van space, are required. Dubois and King commented at the meeting that we are not aware that ADA parking requirements can be waived. So she's saying that there's a requirement for you to have these ahead of time. And the town has a requirement that you have so many spaces per bed, per unit.
Yep.
So I don't know that it's a either or. It sounds to me like it's all inclusive.
Right, but I think what she's saying in the last paragraph is we don't have to put it in the garage. So you have to come up with those spaces, but they don't have to be in the garage.
You mean, tell me you would put ADA people with disabilities outside of your building, and while everyone else has to park underneath in a garage?
I would say that if we sold the unit to someone that needed an ADA space, we would give them, we would create an ADA space in it. But if I create the ADA spaces in the garage right now, I have to physically have a unit, someone that needs that space, because then I don't have the spaces in the garage. Because that's just not like we have 28 units, we have 56 spaces. Right. If I take some of those spaces and make it ADA spaces, I don't have enough spaces for the units in the garage.
Right, but you have enough to use the other spaces outside to make ADA inside. So you can swap,
Swap it
them
in
around.
here and have these be the residential space.
Right. So would you be willing to make a comment that you would have how many spaces were there that required 56? Plus the 3, and will it be some ADA inside or some ADA outside, so at least you'll have those. So you'll need a total of 56 plus 3, so 59, right?
So let me go back. Confer with Mark, we'll have something for the next meeting to address on that.
Can I also make a comment? You said that a lot of these units possibly were gonna be open to Airbnb.
Yes,
So it wouldn't just be the people who owned it who would possibly need this compliance. It could be anyone who shows
Sure.
up, who wants to enjoy.
This is
So, yeah, who's visiting, you know? So
that's a good one.
Joe's time.
Play devil's advocate. If you just put these units, so many units in, only 3 or 4 for ADA. You sell your unit, you're buying a unit, you're handicapped. You're using, you have 3, you've already used up, what do you do in this case? If you can't sell the unit because the guy's handicapped, because there isn't enough ADA parking. So another point I want to make,
Go ahead.
another point, what is the parking garage? People come in with a Jeep and a toolie rack, will they be able to go into this garage? I've been to some place before, I've taken them right off. Those people come up with key, with a key,
But that's
toolie rack, and I got an SUV.
I would see that as being up to the owner. And
Yeah.
saying it would be the height.
We've definitely thought about this. Not that we've gone through and actually done all the architectural, but my recollection was.
Every big
We're trying to build in
definition,
and ceiling
yeah.
height garage, because people are gonna have ski racks.
Scott, I think, your comment about changing spaces, I mean, if you sell a unit to somebody and they've got two spaces. And one of the persons happens to be handicapped, you could end up with more than three down below, if they wanted to say, could you designate it as handicapped? I don't know how you would, I mean, you'd have to designate in the double stacked ones, you'd have to designate the outside one as handicapped, I'm sure. But, so you still have that ability
Yeah.
to do that.
Well, well, a lot of those double stack ones, you couldn't do it because you don't have the width.
Oh, that's right,
We would have to pick ones that are lined up with.
side by
these
side.
Cross hatched areas to do it, so you have that. The five that is required on the
Yep.
side, so.
Main reason why I'm asking this particular question is that you think about it. And the guy finds the unit with ADA. But with the width, the size, we have an area designated for future expansion for ADA to meet it. Because I'm trying to buy a unit, I'm trying to sell it, somebody's handicap, which I've been, somebody, condos that I work at in town, have 2 or 3 handicap vehicles in their property. There's no way near the scope or size of this. Back to, if you want a kid have more than 3 or 4 outside the back, then they have to accommodate these people. That's the point I'm trying to make. Because if you sell a unit, you need more parking ADA, that hasn't been approved by the planning board, how do you go back and get more parking? Unit that has been approved. That's trying to be easy for us, and easy for you and all of us.
Can you also address the amenities?
Yep.
Because that was one of at the last meeting we met with you, you said you were gonna go back and talk to Mark about whether the amenities were gonna be used just strictly for the people that were in the heights, or whether it was gonna be used as for everybody in South Peak.
It's just meant for the people of this building.
That answers that.
It's like a lodge meditation.
No, that's fine, because there was a question of whether or not originally it was proposed it was gonna be for everybody.
Yep.
So. Carol, do you have any other comments questions?
No, that was the
Information.
big question, was, is it gonna be for everybody or? No, everybody's. Not really big enough to accommodate everybody. So.
Does anyone else on the board have any other questions?
Question on the dumpster, just, is the dumpster just for this, or also for the management for the lodge?
Now, what we did based on the comments that we received in the past was this dumpster here, which is a compactor. Is only for this building. And now what we have down here is, you go over there right now, the dumpster is lined up in the parking lot, so. That's really not the most efficient way, so now we have a compact post here that would be for tent.
This will be.
That's just what.
Where currently are the homeowners using as a dumpster? Is it the ones that are lined up with it?
So we used to have them up here, but now they're down by the old temp stores.
Now this, that it's an interesting roof, and Sean started to explain to me about the snow, do you have to do snow removal off that roof, or is there some way, is the roof snow removal not concerned?
It's designed, it's gonna be designed for, like, cause it's a butterfly roof, right? It's kind of like the Kank, it's got the same type of roof structure. Drains up on the roof. You don't have to go up there, it's gonna be designed for that snow.
Cause I saw the snow removal spot over there on the right.
Yep.
It's up there.
It's up in here.
So I was wondering if that was big enough. Snow. removal. You don't have to take the stuff out of the roof, probably is.
just remember, 1989, I found one development, we had 183 inches of snow that one. That's a lot of snow, and then that much that, but. And so potentially, it happened, a lot of weight, especially when it rains.
We can design 85 or 125 pounds.
So what we're looking at, you providing for the next time we meet is to move all the retaining walls out of the setbacks. To redesign the walkway so it's out of the setback. To show us ADA spots. You're committing to doing a variance to the height. And you're gonna give us more design on the interior spaces for mental requirements, and stuff like that. Is there anything else?
Is there any way we
Yeah.
can number the parking spaces just so that we don't have to double count, you know what I mean? So like when you see the plan, you just look at the highest number and see 48.
Yep.
Whatever,
So
some kind of number.
that would be good. So number the spots. The only other question I have is that at the last meeting we were here, I'm not sure if it was you, Scott, but you took down some comments from the public. It said you might be able to address those. One was walkway, like lighting, if you sidewalks, side. If you had any redesign, if you looked at any of this to try to make any changes with respect to any of those comments, or you comment on any of them?
I have not, and what I'm really trying to get a time when both Mark and I are here, when we can get together with Paul, and I apologize, the other advisors, to go through those. We just haven't done, so we will get together with them prior to next.
Right, and I think, the only other thing was, you're not gonna do any lockouts, right? Because we're kind of in trouble with lockouts. At, the dentist,
Yeah.
some of dentist's places, and, so just want to make sure we have enough parking, so we don't, have any parking.
Sure.
Can I ask a question? So,
We're not in public comment yet, but
okay.
soon we will be soon. Is there anyone else on the board?
The only thing I just wanted to clarify, it can be outside of this meeting, but just to figure out, because Sarah is out on maternity leave from D&K, granted these revisions are minor in nature, just want to understand, depending on, like, I was gonna ask to come back on the 13th, that's your next. If that's your next meeting, when does this stuff have to be back in, who's gonna be looking at it?
So in there of that, you sent a memo to the town stating that Nick will be the one filling in for her.
Okay.
And he's familiar supposedly with everything that's happened so far.
It's in the middle of the game.
Okay.
Does that work with you?
Yeah.
Awesome.
In our next meeting, before we get into that. Was there any other questions about the plans? Anything more we wanted?
I just thought of one thing.
Questions?
When you're skiing over there right now, people are parking sometimes back there or some. There's food that they serve back there. But, where do people, like, say my grandmother was coming, where would I offload her and possibly park? Like, if she was disabled and wanted to come to the lodge? Was that even part of this equation at all, or? is
That's right.
So do you mean if it drops somebody off of this building, or do you mean for, like,
The lodge, like, so
the
she wants to see the grandchildren come down, the great grandchildren now come down, and she just wants to hang out in the lodge, like right now on the deck in her wheelchair.
Okay.
But, she has the vehicle now that we can park, actually, it looks like where your parking lot is now.
Okay.
You can park there. Otherwise, there's no way you're getting her up the dirt path.
Yeah.
You know, from the
Yeah.
parking lot.
So this, that was one of the other things too, is we got to, I can't remember if we showed an easement process, but
I just wrote that down, yeah.
I thought we added that to one of the other sheets, but I don't have it printed, so we'll just double check.
We need to, yeah.
So
There's a page that.
I think there is two that go,
Yeah, there is.
Yeah.
so this is, this current, not the, for,
Or,
for the tent, which will eventually become a truck, you know, that far. Because this is the acceptable here, so, you know, we envision this being a drop off, that's why we have this small patch area. So you can pull up, there's no curb there, it's gonna be a flush from, right, so you can come here. Right down the sidewalk, get into the tent, or, that's an ADA.
Okay. And the
Where?
tent doesn't require a city.
All you want to do.
No, no, so if you were to go up to right now, what's in this?
those easements are provided.
C1,
Okay.
2.
Okay.
Page.
So all we did was kind of just move them over. The lead spots are next door.
Not.
Are there any other comments from the board? If not, I'll make a motion to open the public comment. Okay. All in favor? Aye. On public comment.
I have a question. So
If you could, take the mic and state your name, please, so we have it for the record.
I am Kathy Mulhall. I live at 54 Crooked Mountain. And 56 parking spaces will be along Boom Run, that's how I'm considering it. Boom Run is a ski trail, and there'll be 56 parking spaces between the ski trail and Crooked Mountain Road. Like, where are those cars gonna come out onto Crooked Mountain Road? There's a lot of walkers going up and down the street. And second question I have is 56 spots for 28 units, and if they're gonna be Airbnb, I've been watching Airbnbs in South Peak. There's 6 and 7 cars there. Where are the guests gonna park their cars?
That's gonna be up to the, I would think the association is gonna be the association there, the homeowner association. And if someone takes their parking spot, you bet they're gonna be, then I would think. As far as the walking and stuff, Scott's already agreed to discuss with you, some of that.
Where the cars are gonna come out of the building?
Yes, they will
Onto
come
the-
out. If you've seen the plan, you can see where they actually come out of the garage, exit out onto the.
I think I'm Bob Mulhall, I live in the same house. 54 Great Mount. The issue is, we're trying to see when they come out, will the headlights go into our house? But we can't get any definitive, here's our line, here's that line. You know, it's all kind of approximation.
I have something that, what we can do is. What we can do to answer, that question for the Mulhalls is. We can either add it to that plan or not, but we'll kind of drop their house footprint onto one of these plans.
Is that already shown on the 3.0? It's just, you can look at what's their lot and their house right here.
Yeah.
So they're saying that people come out of there, maybe turn this way, it will.
Yeah, and that might be something that we talked about, maybe there's landscaping or something we can do to shield that.
Do you have any other
I have
comments?
just one other question, when you,
Can you grab the mic?
Oh, I'm sorry, yeah.
Yeah, we can hear you, but the recorder can't.
Right.
yeah, you know, understand. Bob Mulhall, 54 Crooked Mountain Road, just when you come back with the architecturals, the building, the exterior drawings we have now don't have windows. So it'd be nice to see where the windows in the building's gonna be. So it has some windows, but most of it's blank.
You'll give us a true set of architectural wall dimensions and. Yeah. How many bedrooms, how many faucets, sinks, all that. Any other questions from the public? Being none, I'll make a motion to close public comment. Second. All in favor? Aye. All right, so we are gonna continue this to, you wanna try and get the first one's the 13th, but
Oh,
you can,
let's
I think
see,
you can be ready for that.
let me see what else I want.
Someone's coming in.
That's on 30. That's-
No.
No, 13 something.
Yeah,
Oh,
that's
so
what the 15th,
This is one meeting.
27th, I think is.
And that's
on three.
Thank you.
Yeah.
Yeah, I think that's the one.
That's on the 13th, like, the building.
Give us a second. With the driveways.
I know I have stuff, but I just parked it in my. So we're gonna be gone 11th and 12th for the 13th, so. But once again,
So anything that comes in late, we're not gonna see. Or unless the. The other people.
if they can give it to Jay.
Well, we won't be submitting anything 2 days before, say that, yeah, that's why I was asking earlier, like. You know, if it's week before, or whatever,
It should,
we'll get it to you.
it could be submitted, can you try and convince Scott to get it by the 8th?
Yes.
To look that way there, it could be in our packets and.
Earlier they, does,
But we should be able to do it.
possibly.
We'll try to get it in early in the.
Earlier,
That would be
No,
good.
like I mean, like 40
yeah,
days
the
before.
5th or the 6th, I'm
So Carol, who else do we have on the 13th? What will it be?
I don't know, I have it in my digital. I'm throwing stuff in the folder. I don't have it.
We were just saying it was probably the master plan.
Yeah, I've got it.
We'll take a look at it.
Matt Ryan for a conceptual.
Matt Ryan. Thank you, Jay.
We have something else too.
But that's a lot. It's not gonna be. I'm not gonna.
Could be fun.
It could be everything. On someone else can attend, but you're here, so. Yeah, so we'll put you on the 13th.
Great, thank you.
Okay, we're gonna do stuff between the bits.
Did you guys make a motion for the continuance?
Well, Matt,
Yeah, not yet.
Okay.
so. I'll make a motion, we continue this hearing again to the 13th of August. Seconded. Joe?
Yeah.
No second. All in favor?
Aye.
You opposed? Okay. You're on for the 13th. Now we go to the agenda here, and we discuss the Alpine Pizza and the Mills Marketplace. Park.
Everybody.
Good night.
Okay, so I'm a little bit at a disadvantage, Mark was supposed to be here, but I couldn't make time, I'm not in the state. So,
You want to
I-
continue this to the 13th as well?
well, I do, I'm happy to, because obviously through Carol, you asked for that information, we prepared it, provided it. If you want to provide me comments, I'm happy to hear that comment, take it back to Mark, and then we can still talk on the 13th. I'll do whatever you need.
If Mark is the one who's gonna make the decision, probably we do it.
I definitely not qualified to make.
If you're not gonna make a decision, and I would say we probably should wait.
Is there any issues that we should bring up to him?
I think the only issues that I can see are, that the Alpine Pizza. So it's identified needing site plan review of the town manager and plenty of lights. So that, Mark should consider. As far as the Millfront Market place goes, there's a lot of insufficient parking. Lack of a lot of parking there. I think we can address that mutually with Mark. This is a little bit, hopefully come up with some, for a negotiation here. I mean, I don't see this board, I'm speaking for myself, I don't see myself saying that what you have over there should disappear. But I think we've got to come to some consensus about where the future goes. I don't have whether there cannot be an increase. And there, or if something changes to lessen it, that it doesn't, they can't go back, because there's 170 something, I believe, lacking parking spaces there, so we're gonna have to come up with something that meets everybody's, I would think. Yeah. And Mark would be necessary in that discussion. Okay.
All right.
So we'll put Mark, we'll put Solding back on the 13th now. All right, then there's a discussion on the master plan update. Thank you very much. They have given us, the master plan has given us. Oh, yeah.
Yeah, they're coming in on the 13th, I believe.
They're coming in on the 13th, and everyone got the price proposal, and you have the master plan itself. Gentleman is going to come in, and he wanted to know if we had any particular questions for him. I thought it would be good, we haven't officially voted to accept them yet. But I thought it would be good before we did that, have them come in and go over what they intended to do. And how, especially with the public outreach, and how this is gonna be coordinated, so that the whole board was on board and had an opportunity to ask any questions before we authorize them doing the work. Does anyone have any comments or about that? How many people do that? How many people do what?
Not a lot.
That's what I was thinking. These are the guys.
So
Oh.
we can't really. Dr. Stoll used to work with the guy that we originally tried to hire to the last one.
Well, anyway, if you have any other questions you might want to have prior to, just like we did with Jason tonight, let Carol know, and she can inform them. They can at least come a little prepared if they want. Do that,
If you have any questions, they want to come prepared.
right. Update on the turning lane traffic counts from Nick. I asked
I
Carol.
think it's coming, I think it's coming at 20,000.
Either I put them.
Yeah.
Did you have any more follow up with them on installing that other comment?
Yeah, and I think I sent them to.
He said he couldn't do it, but I didn't know if they were going to do it.
So they could.
They just
Said
did
the
that
unfortunate, didn't think about it.
early enough.
To get the first, then they,
When my wife walks her dog, she notices, and I do, and she knows people up there in Fort Bridge who can make comments that they don't go out Forestman Drive anymore. They go out through Reckless because of the because of everything that's going on. So I said, well, geez, we don't have a camera there. Maybe we should have a camera so that we can put back to how many are coming in and out of there. So I talked to Carol, and she talked to them. And they're gonna put another counter there. Obviously, like she said, they missed the first round in May, but usually you get July and the next. Well,
yeah, it's in your packet, it's behind all the parking stuff.
and
And then there's a couple maps, so what I sent to show him how important it was, because
right,
how large the Forest Bridge is.
how much is left for it to grow?
So he said, yes, we can place a camera along Paint Crack Road to capture some of that diverted traffic. Sadly, won't be have data on this traffic compare the day counts at the other locations, and I said, like, okay. Is there anything I should know about Main Road is private or public? I said it's a town and take classified. And then you want to know if the neighbors are gonna mind hearing the tube sit by the tire. Don't like to try to place cameras close to residences, and I explained that big guy on both houses that is working on that house.
I think that would be an interesting count, because I don't think it's ever been done before on that. Okay, so we're also in the midst of getting a work session scheduled with Karina. She's on vacation, but we're looking at August 20th. It will be a work session. It's not a normal planning board night, so people can put that on your calendar, see if they can make it. There is a training reminder about training that's coming up on the 30th with NHMA.
Oh, wait a minute, isn't that the 20? Wait a minute. That's in July. Yeah, the training is the 30th.
30th of July, right?
So,
Um,
now you're right here.
We can go down to the new business request for an extension. Ethan Conley, you see here? Ethan, are you on Zoom?
No, he wasn't gonna, it's gonna be, his partner there, first.
Is there someone here representing Coolidge Ridge subdivision? If there's not, we won't take it up. Well, I mean, it's only for a,
Kyle McManus.
it's only for an extension, but only most of the extensions we've given that people have come in their own words and asked for an extension. Why? And I think it's important that we probably, you know, I mean, it's not a big deal, but it's still.
Signed application with the reason on it. I think we should bring it up.
Although,
Oh, wait, that's Mike's not here. I'm sorry, Sue, go ahead.
On the hotel that being built now,
No,
no, the one that they're just breaking ground.
yeah,
He wasn't, and my husband came to that meeting, he wasn't here at first, and then he got on Zoom, and you guys weren't going to, I believe that there was a question on if he could grant it if he wasn't present, I'm just saying that, and then he was able to get on, so.
well,
I mean,
I mean, I understand the application on but I also understand that Carol told me that he had to be. Because she asked me about it, and I said, well, everyone, in fairness to everyone else who's coming to ask for an extension. Will be it. Is that correct?
Does it expire tomorrow?
Yeah.
It expires on the 4th, but
24th.
not bad. You have a conversation about being here as part of it.
Well, he's gonna do public for out of the country, out of the state. So his partner, Kyle McManus, was supposed to.
I understand it. I mean, and it's just purely for making sure that the public is aware and that this was advertised, but it was done, he came in late. You know, this wasn't something that had been on the agenda for a while.
Well,
It just got on the agenda.
Derek Blake is his attorney. And Derek Blake is the one who's reminded him that deadline was coming up. And they looked at both of the subdivisions, and because he had a modification to the subdivision of one of them. We didn't have to have us for extension because that automatically picked it out a year from that date. But this one was. I forgot about this.
He's not changing anything. Right?
No, he's not
He's
changing.
just simply asking for,
He's waiting for the state on the AOT. Because
that's what it said.
there could be some modifications that have to be made. That then will require Ray to make further recommendations for modifications, like moving, reviewing that.
I just want to do this right. The only reason I want to do it right is because it took so long to get this through and there was so much about a comment that I just wanna make sure that we do this right and. You know, there was a lot of comment for this project, you know, I just,
Well,
It-
here's the problem, it's gonna expire.
I know, I hear you. That's not our problem, they didn't come in a little early, but it's certainly. I agree with OJ in a way that we, you know, we probably could approve it, but. What if the abutters? Cause they really only got. Literally probably a, what, 2-day notice? You know, so if they wanted to make any comments on it while we were considering this, it would be tough. We met the letter of the law, it's only 24 hours, but still, it's not 48. What comments could they make? I don't know.
I see, they're only asking for an extension, there's no changes in the
I know,
thing, so. We couldn't even
is there,
react to anything that the abutters said about the project. It's just a matter of the extension.
I know,
And when you are waiting for the state AOT, that's the state protecting the town.
correct.
You know,
Well, you can't not refuse anything because we're waiting for a state permit anyway.
Correct.
So,
The other thing to look at, maybe give the extension, but it's still be able to be and make comments on when you get next meeting to come for.
If you didn't grant the extension, what would happen?
he would have to come back again. He would,
You don't know.
he would lose his permit, right? I mean, I'm not in favor of not granting it, I just wanna make sure we're doing the right thing, so. Because that was one of the longest applications that I've ever gone through in the planning board, that I've been, I can tell you. So I just wanna make sure we do it right.
Can you grant it
I'll,
prejudice, like say that he needs to present it?
I'm like, I'll make a motion, that we grant the extension. For one of the two, for the Ethan Conway stuff, is it both of them, Carol, 1 and 2?
He's just asking for the second one because you've already essentially given him an extension for the other.
So
Because he modified the other one, it's not modifying this.
is there a number?
Yeah,
on there?
tax map 114.
49.3,
Okay, so it's M 114,
it's the one.
lot
that's on
049.3.
0.3.
That's the first one, 0.3, second one, just plain 049, so which one is it?
0.3.
That's the one we need to give them. Okay, so I'll make a motion that we approve that extension. Now, that's a 1-year extension.
Correct.
Second, Joe second. All those in favor?
Aye.
Any opposed? Okay, that's done.
Okay, and then, so that's been surgery that changed, so you have the upgraded. Of my life.
I will make a motion to adjourn. Second it. Motion second, all those in favor? Aye.
You can adjourn, but, so you have notebooks. And, I have signed, they have numbers on the back. And so, this is probably the 3rd or 4th time that I've done notebooks. This is what has happened in the past, the notebooks have disappeared, people take them home, we never see them again. When you have a meeting, people don't have the notebooks, blah, blah, blah. So you can leave the notebook here, because you now have an assigned number in the back of your notebook. I have a list on the front. And you have to return them, when your service is done. And like a single change, I'll give you pieces to talk out, like a new version of this. But they are very expensive to do. And somebody had bragged me they were using it as a storage job. I can't remember that one, but.
I do that reading at night.
So believe.
So let's discuss this a little bit, because I think
Second home in a, that's what we, the last, I didn't send home. When I redid them in 2022, I said, just leave them here. And you can leave them here, but if you take them home, you need to bring them back.
I think, to me, the more important thing, Carol, would be the responsibility of us to make sure that we don't lose this, so someone comes to you and says, I need another one. Is there any way that we can put it in?
They suggest to do $200. And that's why it's in the front of the,
So maybe.
in the front of the, it's called, that these notebooks are very costly to make both in time and cost. 200 replacement costs if the book is not returned. You know, it's the first page.
I got some 1988, want one?
So,
Would everyone agree to that?
Yeah.
Okay.
I mean, I'm good at leaving mine here, I prefer to leave it here.
Yeah.
and that's
It's
why,
gonna be,
Yeah.
safe here.
and all
I get a lot of her online stuff. I sometimes have to look through and get verification.
it's number 4,
Am I looking at the right thing?
number 4.
And look in book 10 going on.
Thank you for making it.
Yeah, it's great, great, great.
Most of you, you have already, but the rest of you, I gave you the master plans, I don't have the additional. There are more than 100 pages and other.
The last master plan?
The last ones that I gave you, you might have them in your book. Or you can just park them in your book.
Also, they're not in.
They're not in yours,
Okay.
yours.
Oh,
They are in the new people's.
well, okay, all right, I got that back. That's gonna offer you mine because I have mine. And then,
Anyway, so you can take your master plan from your old notebook and have it. Just put it in here as number 10. Good spot for it.
All right, we're adjourned. Carol, here's it. So you get a lot of
I'm so happy. I'm looking, I'm like,
Thank you,
how
Jay.
am I gonna get this, all my bites here? What are you doing? Yeah, my being.
Thanks, guys.
Thanks,
Thanks, Patrick.